aside from a curative instruction to the jury, what else can the judge do to ensure that this jury isn't biased against Melly?
This is an egregious breach of the ethics code as well as the judge's ruling. This was an intentional decision to circumvent that. So the judge would likely give a very strong curative instruction to the jury to explain to them that it was inappropriate and they're disregarded. And I'm going to also say, from a prosecutorial standpoint, this is a unforced error by them. Even though the judge denied the motion, because I think that was the appropriate thing to do, they've gone through jury selection, they're well into this trial. What they've done is create a significant appellate issue in the case, the prosecutors, by doing what it is that they did. The judge's remedies are to tell the jury that it was inappropriate to do, and in truth, I have seen instances in which judges have referred these things to the ethics committee because prosecutorial overreach. This is clearly a way of circumventing the judge's ruling, and not only are they going to look bad in front of the jury, but I'm going to bet the judge is not going to be all too happy this point going forward and giving them any level of the benefit of the doubt going forward. It was a bad prosecutorial move. Last point, Anjanette, when I was the county prosecutor, if one of my assistant prosecutors circumvented a ruling like that, they would not have a job.
Very interesting. Well, it'll be interesting to see what happens with Christine Bradley as they proceed. There was a curative instruction given on one of the issues on Thursday, but it'll be interesting to see if the judge goes a step further today when the testimony resumes in just about 90 minutes or so, if that juror is feeling up to it. I'm going to send this next question to you, Terry Austin. This is from Janet T. from YouTube. This morning, the judge gave out the name and medical information of one juror. Would this be a reason for a mistrial, or what impact will that have on the trial, if any?
That's an excellent question. I don't think it would be a grounds for a mistrial, but from a privacy standpoint, you would think that the medical information would not be shared. I did hear the judge talk about this juror, and he was trying very hard to be a bit on the vague side. He didn't give any details. He simply announced to the courtroom that there is a juror, she is sick, she is getting treatment at this point, and she may be back between 1:30 or 2 o'clock. So he did mention the dehydration, but I don't think he gave enough specifics for it to be a real breach of privacy, and I definitely don't think it's a grounds for a mistrial in this case.
Well, Andy has to make this known for the record, and everybody's sitting there, right? You've got both parties, the state and the defense, sitting there like, what's going on? We're ready to go. You denied our mistrial request. The defense is saying that. So they're going to note these things for the record, and I don't think a mistrial would be likely either, just my 2 cents. Our next question, Skywalker from YouTube. Is the driver intended to testify against Melly? Brian Buckmeyer, what are your thoughts on that? They're talking about YNW Portland.
Yeah, is he intending to testify? I would imagine no. If he was going to take the stand, it would be a lot of, I plead the fifth, I plead the fifth, I plead the fifth. The question becomes one of two things. One, why? Is there any incentive for him to testify? Is he going to get a lower sentence or a lower offer? We already know that they're not seeking the death penalty against him or any as serious as YNW Melly. And then two, who could compel him to testify? It's not the defense. The prosecutor couldn't because he has the Fifth Amendment right. So I would probably give it like a 2% chance, if that he would testify at all.
Yeah, I don't think there's any way YNW Portland's getting up on the stand because I'm not sure the prosecutors even want to give him a deal or give him any type of consideration given what happened in this case, at least the allegations about what happened with these 2 young men being shot to death, the prosecution contends, in cold blood from the backseat of a vehicle. Let's get to some Twitter questions now. Bob, I'll send this one to you. It's from @22Roscoe. And he asks, will YNW Melly take the stand? Bob Bianchi, what do you think? And do you think that could change if Portland testifies, which we don't think will happen?
I want to go back to the last question real quick. You know, the prosecution always can give immunity to a witness that's got the Fifth Amendment if they really want his testimony, because that can't be used against him in a subsequent trial. Listen, no defense lawyer, nor certainly somebody who has not looked at the file and is not involved in what the defense may ultimately be, is going to make a prediction decision. Usually the decision as to whether or not a defendant is going to take the stand is not made until after the state's witnesses have all testified. And you have to make a balancing equation when you're consulting your client and say, listen, did the prosecution prove its case beyond a reasonable doubt? Because to use an old axiom that my mentor taught me, juries love to convict defendants from the mouth of themselves on the witness stand. So it is an extremely personal and nuanced decision. Last point, I'd say, Anjanette, the one caveat and curveball when you have a celebrity like this, there's a lot of ego. There's the court of public opinion. There are his fans that he wants to cater to. And sometimes that drives them to do something that's good in the court of public opinion, but disastrous in a court of law. We'll have to wait and see.
We will definitely have to wait and see. And, you know, YNW Melly's fans, I'm sure, want to hear from him. They are very active on Instagram and TikTok. But whether or not he gets up there and puts himself in the hot seat, that's a decision that is totally up to him. His counsel can, of course, weigh in with him and advise him, but in the end, it's his decision to make. Our next question, Terry, I'll send this one to you. Tay from YouTube asks, will the prosecution need, in all caps, the weapon used to get a conviction?
Well, what they need to do is to prove to this jury beyond a reasonable doubt that it was Melly who was sitting in the backseat of that car on the driver's side who shot those 2 kill shots to both of the victims. And what they need to do is to have some forensics. They've already had some experts who came in to try to say that the trajectory of the bullets went a certain way. But on defense, they really did a great job cross-examining those witnesses and saying, look, you don't have the height, you don't have the distance, so this is basically just a guesstimate as to where those shots came from. So if they can't put the gun in Melly's hand and if they can't show where those bullets came from, I think the prosecution is going to have a very difficult time. Plus, the defense has already laid the foundation in the cross-examination and certainly in their opening statement that the investigation was very poorly done. They did not follow up on leads. They did not even follow up with questions to Henry, who is the co-defendant, and that case has now been severed from this trial. But I definitely think that those are the 2 areas. One, the fact that they didn't follow up with these investigations, and 2, the bullets. It's going to make it a little bit difficult for that prosecution to prove that it was Melly who did this. So right now, I think the momentum is on the defense side.
Very interesting take, Terry. And you are there in the courtroom, so we're going to be really excited to hear more from you as the days go on about what it's like in there, sitting there kind of taking this all in and what's going on in the gallery. Facebook question for you, Brian Buckmeyer. Catherine Vargas asks, if there were additional jurors missing today, on top of the one that was in the emergency room, at what point would you call in alternates?
I mean, I don't know why he's not calling an alternate now. You're able to call an alternate for any reason. A juror is stuck in traffic, a juror is sick, illness in the family, whatever it may be. I don't understand why we're waiting on this juror. Maybe it's a fear that if you just give one alternate into the main jury pool, then they'll start, quote unquote, dropping like flies. But any point in time, I don't know why we didn't start early this morning. Maybe the judge wanted the morning off. I don't know.
We don't know. It'll be interesting to know. Maybe they feel like we don't need to call in an alternate. We can just delay a couple of hours. Maybe they don't want to lose one, because this trial could go several weeks from what we have been hearing. All right, everybody, we are going to take a quick break, but we want you to stay with us as we continue to take your questions this hour. So keep submitting them to us on all our social media platforms: Twitter, YouTube, Instagram, TikTok, Facebook. We'll get to as many of them as we can, and stay with us. I'm Anjanette Levy. You are watching Law and Crime. We'll be back in a few.